All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Good afternoon by 2 minutes. Madam Clerk, if you call the case, please.
Case number SC 2024-0734, A.G.R, an individual, and C.S.R as parent and next friend of A.J.R, a minor, be the City of Irondale. In SC 2024-0788, A.G.R, an individual, and C.S.R as parent and next friend of A.J.R, a minor, be the City of Birmingham. Both cases are appeals from the Jefferson Circuit Court. Arguing for the appellants, the Honorable Todd Wheelis and the Honorable Meredith Carpenter. And arguing for the appellees, the Honorable Michael Jackson and the Honorable Joseph Abrams.
Y'all ready? Okay.
May it please the court. Good morning, Chief Justice Stewart and honorable justices. We're here today about two sisters. We are asking you to protect the rights of these sisters who were minors when they were sexually abused by defendant Galilee, a deacon at a local church, over several months in 2017. The plaintiffs allege that employees of the cities of Irondale and Birmingham observed inappropriate conduct, but failed to act, placing these children at further risk. A.G.R is now an adult, and A.J.R is still a minor. They appealed the dismissal of their claims against both cities under Alabama Code Section 1147-23, and they are seeking recognition of their rights and the rights of all children in the state of Alabama and ask that they should not be barred before reaching the age of 19. The issue here today is about harmonizing two statutes so that municipalities receive timely notice, but that children are not stripped of their rights before reaching majority. An Alabama child should not lose their rights to justice before they are even old enough to walk into a courthouse. The legislature wrote Alabama's tolling statute to safeguard children, and nothing in the municipal statute repeals that protection. This case presents a novel legal question as the resolution will have significant statewide impact. This court has never addressed this precise conflict. The answer will decide whether Alabama minors lose their claims against municipalities before they are even old enough to accrue the right to file them. The legislature's longstanding policy is to protect minors from losing their rights due to age. That protection should not vanish simply because the defendant is a municipality. This case presents a direct conflict. Does the municipal notice statute extinguish a minor's claim before the minor turns 19, or does the disability tolling statute preserve the claim until majority? This court must now decide whether those safeguards remain intact. Thank you.
May it please the court. Alabama Code Section 1147-23, which is the municipal tolling statute, does not comply with the legislative intent created in the 2019 update to Alabama Code Section 628B.
So let me stop you there. And your colleague mentioned that we had not addressed this. The Parton v. Huntsville case seems basically directly on point to me, and I find it very difficult to find for you from my chair, and I'm one of 9, without overruling that case. How can we find for you if we don't overrule that case?
Justice Cook, thank you for that question. We believe the law has substantively changed dramatically since 1978 when the Parton case was decided by the Alabama Supreme Court. That case was a medical malpractice claim against a city hospital. The city of Huntsville was running the hospital. A child was injured, had a birth injury, and filed a claim a couple years later. At the time, they said that the 6-month notice statute applied. In the interim, since 1978, the Alabama Medical Liability Act has changed. The Alabama Medical Liability Act now expressly understands that 628 can extend the tolling statute. Also, in 2019, the Alabama legislature, and I apologize, the Alabama legislature in 2019 modified 628B to extend to sex crimes against children. And it specifically identified.
That's the statute of limitations would they modify.
Statute of limitations. Yes, sir. It modified.
It didn't modify the claim statute.
It didn't modify the notice of claim statute. That's where the conflict is. And we believe this court today has the opportunity to harmonize those two statutes. The Alabama Supreme Court, historically, when there are two statutes that are at conflict, they give deference to the more specific statute. I believe it's in pari materia. I think that's how you say it. That's how we say it in Clay County. But it's harmonizing the statutes. So when you have a specific statute like 628B that says we're going to extend the statute of limitations for children, the cause of action does not accrue until they turn 19. And there are case after case after case in Alabama that talks about when does a cause of action accrue. Well, 628B specifically says the cause of action doesn't accrue until the child turns 19, until they reach the age of majority, which is directly in conflict with the pardon case. The law has changed since pardon. Now, it's not just a cause of action for a car wreck or a cause of action. In this case, as in 628B, it directs us to specifically identified sex offenses that are described in 15-28-5. Okay? The cause of action in this case that supports the claim by the two minor children are specifically listed in 15-28-5. The defendant in this case has pled guilty to two of the crimes listed in 15-28-5 that are specifically pointing from 628B. So when you ask me how is this case different than pardon, the Alabama legislature specifically changed the law and extended the statute of limitations for minors that suffer sex abuse and give them under 628B to the age of 19 and 6 years.
But they didn't change the claim statute.
Well, I would take the position, Justice Cook, that and there is case law in Alabama that says when the legislature changes the law, they're on notice of existing statutes. They have knowledge and they're aware of the law. So when we take the position when the Alabama legislature came in and modified and codified specifically 628B, which extends the statute of limitations for minor children that are the victims of sex crimes, they understood the municipal tolling statute was in existence. They have knowledge of that under Alabama law, under the laws of the Supreme Court here. They're vested with knowledge of what the statute says. They didn't exempt municipalities.
They're vested with knowledge of our Parton v. Huntsville case, and it's been there for 50 years, right?
Yes, sir. That case has been there for 50 years, but they didn't, when they changed the law, they didn't say except for municipalities, Justice Cook. They extended the statute of limitations, period, for children that are the victims of sex abuse. They didn't exclude any defendants. So they specifically, and we believe when you look at the construction of the statute, 628B, this is not a general statute. This is a specific statute that specifically identifies a protected group, children, that are, if they're allegedly subjected to sex crimes, then it is specifically extending their right to bring an action. So the municipal notice statute is just a very general procedural statute.
They can bring a cause of action, right? It's just we're talking about a claim statute that involves municipalities. They could bring a case against someone other than the municipality. You wouldn't have this argument. So don't we really have a conflict between two statutes potentially?
Absolutely.
And how should we resolve those?
We believe that the court should harmonize those statutes and recognize that the municipal notice statute effectively is acting as a bar against claims in direct contravention, directly flying in the face of 628B, which has been a subsequent action of the state legislature. The state legislature came back in and says, hey, we understand that there are children that are unable to file claims until they reach the age of majority. We're going to extend the statute for 6 years after they turn 19. So the legislature had the intent to do that, and they have done that. We are here because the statutes haven't been harmonized, and we are asking that the court harmonize those statutes.
Well,
Counsel, I'm sorry.
are you asking us to overrule pardon?
Yes.
We cannot do anything without being asked.
Justice Wise, yes, ma'am. We are asking that you overturn pardon.
Counsel, you had made a very logical argument about that the legislature knows what's in the claim statute when they knew what was in that when they passed the amendment to the statute of limitations involving sex abuse victims. How would you respond to the argument on the other side that says, yes, they knew about it and they didn't do anything to the claim statute. Therefore, instead of overruling it by what they did, they actually left it in place. And so what would your response to that argument be?
Justice McCool, I've run out of time.
The answer is,
May I answer?
yeah.
Thank you, Justice McCool, for your question. I would say that it would be cumbersome for the legislature to try to identify every particular category of potential defendants. When they codified 628B, they didn't try to go in and say, well, what about principals at high schools? Or what about police officers? Or what about deacons at a Baptist church? Or what about all these? They didn't. They just said specifically, we're going to extend the statute without accepting it for anyone.
Okay. Thank you.
Thank you.
Are y'all ready?
All right. Good morning, Chief Justice Stewart and Justices of the Supreme Court. May it please the Court. I'm representing the City of Irondale. Much of what plaintiffs just argued was not argued in the trial court below and has been waived. In response to Irondale's motion to dismiss, there was no mention of Section 628. There was no mention of the word accrue or any form of that word in plaintiff's response to either city's motion to dismiss in the trial court. There is no request in the plaintiff's principal blue brief to this court to overrule the Parton v. City of Huntsville case or any of the cases relied on in Parton. Plaintiffs do say in their reply brief that they asked to overrule Parton, but that's not sufficient. They've got to ask for it in their principal brief. We contend all those arguments have been waived. Nevertheless, we'll address their arguments on the merits. Now, this case involves...
What did they argue? Y'all's motion was first before Birmingham filed their motion.
That's correct.
So what did they argue in response to your motion?
They just argued basically public policy, that public policy what should allow... I'm probably not doing their argument justice. I'll let them make their argument, but I mean, they did just argue that it was just unfair and for these minors to be denied their day in court.
There was no argument about a conflict between 682B. No
Not
argument.
in response to Irondale's motion, 6228B. No, that was not mentioned at all.
Okay, thank you.
So this case involves claims against two cities, and claims against cities are just different. Why? Because the default rule for cities is that cities have immunity unless there's some statutory exemption. And when the court held in Parton versus City of Huntsville case, which we've been discussing, the notice of claim requirements now codified in 114723 is an integral part of the legislature's limited exception that they've carved out for immunity for cities. And the plaintiffs in their brief discussed the history of 114723, and they say it was passed in 1907, and they say there have been no material changes or updates. And we agree with that. There haven't been any changes at all. So this court's interpretation of that statute in Parton, and going back to 1937 in the City of Birmingham versus Weston case, for 88 years, this court has said that you can't, there's no exception for minors to the notice of claim statute. They still have to make their claim to the city within 6 months, or their claim is barred. Now, the plaintiffs claim that when the legislature amended Section 628 in 2019 by passing Alabama Act 2019-480 to add what is now subsection B to that statute, the legislature gave injured persons who are minors more time to file their claims, their notice of a claim to the city, but you won't find that anywhere in that statute. The amendment to Section 628 addresses only giving minors who allege they were sexually abused additional time to file civil actions or lawsuits that would otherwise be barred by the statute of limitations. Doesn't address at all claims against cities or the notice of claims requirement. In fact, in the Parton case, this court addressed a nearly identical argument. The medical...
So in Parton, I know our court talked about the majority rule because other states have the same issue about a claim statute versus the rights of minors. And so we said in Parton that the majority rule was that the claim statute would be enforced. Now it's been 50 years. The legislature has done some revisions here to the statute of limitations. Do you know how other states are dealing with this now? Is it still the majority rule, the claim statute, the notice of claim statute applies even if you're a minor?
I don't know the answer to that question. I know that the Alabama legislature has not taken it upon itself to change Alabama's law, and I don't know what the other states have done since 1978.
So the claim statute uses the word accrual. Do you take the position that the claims for the minors had accrued, and therefore the notice of claim statute bars their claim?
Undoubtedly that their claims had accrued. One of the plaintiffs is still a minor, and she's brought her lawsuit. Well, you can't bring a claim that hasn't accrued. So how could, if her claim doesn't accrue until she turns 19, then her claim would not be ripe and subject to be dismissal for that reason. And the Section 628B itself talks about when the claim accrues when a person is under age 19. So it doesn't, you can't square their interpretation of accrual to not be, that you have to be, it doesn't accrue until they're 19 with the language of the statute 628B. It just doesn't work. So they are simply wrong about what accrued means, and also when you look to the language of the preamble for the Act, Alabama Act 2019-480, I think they refer to it as Senate Bill 11. It's the same thing, but It specifically provides to amend Section 628 to provide for the statute of limitations for civil actions involving a sex offense. And this shows it was not changing, it was only changing the statute of limitations, not changing the notice of claim statute and the time for submitting a notice of claim to a city. They also argue in this case that it is a matter of public policy, and we agree. The legislature has made the public policy. Plaintiffs are asking this court to substitute their desired policy for the legislature's policy. The policy behind the legislature's 6 months' time for submitting notices of claims is to give cities prompt or early notice of any potential claims, to allow cities to investigate them promptly, to allow cities to preserve evidence, identify witnesses, and to make assessment of the claim and possibly resolve the matter before litigation. The legislature's reasoning seems to be that if it's going to remove the immunity that cities have, then it wants to give the cities, which have limited funds, taxpayer funds, an early opportunity to plan and address their claims promptly. So that's the public policy the legislature has addressed. And to allow someone to bring a claim previously unknown to the city 7 or so years later with no notice puts the city and its taxpayer funds at a significant disadvantage. So this is the policy made by the legislature, which should not be substituted by the policy choices of judges. Reversing the dismissal in this case and essentially overruling Parton would be just that, judicial policymaking rather than legislative policymaking. So for these reasons, and for those in our brief, the City of Irondale asks this court to affirm the dismissal of the plaintiff's case. Thank you.
Thank you.
Madam Chief Justice, and may it please the court. Once again, my name is Joseph Abrams, and I have the good fortune of representing the City of Birmingham in this matter. Now, before I delve into the crux of the City of Birmingham's arguments in opposition to the appellants, I'd certainly be remiss if I didn't first re-emphasize the fact that the abuse that the young appellants, the young minors in this case, that they were subjected to at the hand of defendant Galletly were horrible, reprehensible, and deeply disturbing. And our thoughts and prayers go out to those young appellants. But while the appellant's circumstances are definitely invocative of sympathy and compassion, their arguments for relief would require this court to abandon its established precedent. It would require this court to engage in legislative process, and it would require this court to completely frustrate the underlying purposes of the notice of claim statutes. And that is specifically because this court's established precedent in Parton versus the City of Huntsville, as well as City of Birmingham versus Weston, provided the appellants with a pathway to compliance with the notice of claim statutes found in 1147, 23, and 192, which are read in para materia, read together, without any need for expansion as the appellants are currently suggesting. And that pathway was through their parent, their guardian, their next friend, C.S.R. And unfortunately, in this circumstance, the appellants did not file notice of claim with either of the municipal defendants until nearly 7 years after their parent, their guardian, their next friend initiated the criminal process on or about November 24th, 2017. Because of that non-compliance with the notice of claim statutes, which are a condition precedent, the appellants are barred from recovery from only the municipal defendants in this case. And I think that's something that's really important to emphasize, that the appellants still have a pathway, a viable cause of action against the other defendants that were named and sued in this lawsuit, just not against the municipal defendants. So we've heard a lot about this court's decision in Parton, and it's the City of Birmingham's contention that this court's precedent in that case is binding and virtually dealt with many of the arguments that the appellants are advancing today. As you heard from counsel on both sides, that case again dealt with a minor who was injured while receiving treatment at a city-owned hospital facility. That minor challenged the constitutionality of the notice of claim statutes under equal protection and due process grounds, and also in a very similar manner to what's being advanced by the appellants in this case, also argue for the extension of the statute of limitations that apply to medical malpractice cases that impacted minors. Now, this court in Pardon determined that the medical malpractice statutes that dealt with the statute of limitations could not be grafted and applied to notice of claims statutes. It was pretty emphatic in that delivery. Also cited in that case was the City of Birmingham versus Weston, which said specifically if a statute does not provide a carve-out, an exception for minors, that to do so would be reading in language that was not in the statute and would not be engaging in judicial interpretation, but rather would be the court engaging in the legislative process. So for the past over nearly 50 years, the court's decision in Pardon and Weston have been on the books. The legislature is imputed with knowledge of this court's judicial interpretations, and when it enacts or amends legislation, it does so with full knowledge of existing laws, including this court's decisions in Pardon and Weston. And in that time, excuse me.
Help me understand why the legislature might have a different rule for claims against a city by the minor versus claims against everybody else by a minor.
Well, I think that's an excellent question, Justice Cook. And I think it goes to the underlying purposes of the notice of claim statutes. I think there's some conflation between notice of claim statutes and statutes of limitations. So municipalities as creatures of the state are municipalities as creatures of the state have limited liability for tort actions. The only actions that a municipality can be liable for are those that the legislature carves out. So it's a municipal creature. It's a creature of the legislature. The legislature carves out what procedures and what requirements a plaintiff would have to satisfy before commencing an action. But the underlying purposes of the notice of claim statutes are to allow a municipality the opportunity to investigate claims and either resolve them or defend them. So this is something that the legislature clearly outlined or identified as something that is different from any other type of defendant. And because of that, provided the notice of claim statutes 1147-23 and 192
Counsel.
outline.
Counsel, follow up on that. And this is a hypothetical, but I guess just address this question I have. it's not the case here, but let's just suppose that a city employee had abused these children on city property when they were, 11 or 12 years old, whatever. All right. And they didn't tell anybody, which happens, in my experience, quite a bit until they turned 18 or 19 years old. Are we just stuck with you can't sue the city because obviously under your interpretation, I believe the claim accrued at the time they were abused, but nobody knew. And so what, and I'm just asking, are we stuck with just, they don't get to sue the city?
Well, I think under those circumstances, the city would be barred. Their claims against the city would be barred for noncompliance with the notice of claim statutes. But the facts in this specific case are different.
I understand.
And we know that because the young appellants, they had someone to help them comply with the notice of claim statutes. And we know that very specifically because that same person, when she learned of the abuse, she did not rest on her laurels, she did not rest on her hands. She initially reported the abuse to authorities and commenced the criminal process. She could have also complied with the notice of claim statute. So under the facts that are currently before this court, there was a pathway to compliance with this court's precedent and with the notice of claim statute.
But would you say that if we agree with you on that and that the claim statute just applies, my hypothetical they would also be precluded in that case. Would you agree with me on that?
Well, I'd certainly say they potentially would be precluded if they didn't have someone provide
If they never
compliance.
told until years later.
Correct.
Okay.
And I say as a analog to that question, a public policy impact that impacts municipalities that hasn't been addressed is the fact that conceivably a young person could be subjected to some form of injury or abuse, and a municipality might not be placed on notice of that claim or injury until nearly 2 decades after it happened, which would frustrate the underlying purposes of the notice of claim statutes that the legislature carved out specifically for municipalities. In that much time delay from injury to reporting, vital information is lost, administrations change, facts and circumstances change. So that would frustrate and complicate, from our opinion, the purpose of the notice of claim statute.
Can the notice of claim statute be waived? I mean, sometimes we let statute of limitations parties can agree, but is it just so ironclad that the city could never waive the 6 months requirement?
Well, I think that's a great question too, especially when in the context of the separate and distinct nature of notice of claim statutes from statute of limitations. So statutes of limitations can be healed with procedural mechanisms like relation back and under Rule 13 and 15 of the Alabama Rules of Civil Procedure, whereas notice of claim statutes are statutes of non-claim. So they are a condition precedent. If they are not met and satisfied, that is a complete bar against recovery against only the municipal defendants.
So the city couldn't waive that if they wanted to somehow.
We certainly say that the city could not waive it in this situation because it certainly was filed well after the 6 month presentment time contemplated in 1147-23. So just in sum, what the appellants are asking you to consider, the arguments that they're advancing for you to consider are not novel. This court has dealt with this issue in a very similar fashion in pardon. The appellants, frankly, do not raise the issue of overruling pardon until their reply brief. They certainly don't advance it during the trial court, don't advance it in their initial response. They wait until the reply.
I know that counsel for City of Irondale has said that none of this has been preserved. Does City of Birmingham feel the same way, that none of these issues have been preserved in the trial court?
Justice Wise, there were issues advanced at the trial court about the application of Alabama Code Section 628B. However, the extent to which they now argue their public policy arguments are different and varying from what was actually advanced at the trial court level. So to that extent, we would argue that they were waived. So again, for the appellants do not ask this court specifically to overturn pardon. And frankly, the legislature they are imbued with knowledge of this court's interpretations of the law and chose not to amend, alter, or modify the notice of claim statutes. So for this court to do so would not be interpretation. It would be involving itself in the legislative role, which this court has oftentimes declined not to do it. And as my parting thought, I do want to reference this court's decision from back in April of this year in Ex parte City of Orange Beach, where this court said the legislature is presumed to be aware of this court's decisions. So if a decision from this court is inconsistent with this statute, and the legislature has had ample time to correct you, but has taken no steps to do so, then arguments for adhering to the doctrine of stare decisis stand on firmer ground.
Thank you, Mr. Abrams. Hang on, Mr. Abrams. I think Mr.
Just have a real quick question. Is the claim statute, is it procedural or is it merits based?
It certainly would be procedural. It's a procedural condition precedent to being able to commence a tort action against a municipality.
Thank you. Counselor?
May it please the court. I wanted to respond to a couple of questions that some of you had while the appellees were providing information. I believe it was you, Justice Wise, who asked a question regarding preserving the issue down in the trial court. We filed several pleadings at the trial court level, and we had a couple of different hearings at the trial court level. Some of the pleadings addressed the public policy issue, tolling the 6-month. Due to the tolling statutes address public policy, it didn't specifically list 628. Other pleadings listed 628. In both of our hearings that we had, we did address specifically 628. We talked about what that was. So to answer your question, the issue was discussed at the trial court level via oral during hearing or in part in some of the pleadings.
But just to be clear, the Irondale motion came earlier in time, right?
Yes, Justice Cook.
And your written response to the Irondale motion didn't raise that.
Yes, sir. Justice Cook, it was a sort of a bifurcated situation. The Irondale issues were dealt with. There was a pleading, there was a hearing. In the interim, Birmingham had some pleadings filed, additional pleadings filed. We filed a number of amended complaints trying to get some information correct down at the trial court level. And so once that was set for hearing, the 628 issue was addressed on the issue of public policy, because as we said today, this is a public policy issue that has a novel impact on the entire state of Alabama. And Justice McCool, I really loved your question about how this affects children that don't disclose. I, in my former life, was a social worker and a supervisor for D.H.R. for many, many years before I became a lawyer. And that is a huge thing that I have seen through the years. So the city's take on this would have you to say that if these children who were abused don't have a trusted adult with whom they can disclose to, and they don't tell anyone, they're forever barred from getting the justice that they so deserve. And that's just heartbreaking. And that's why we believe that the legislature made these changes, and they were very specific under these sex crimes under Title 15 and the very narrow list of what those were. And two of the two charges that Defendant Galletly pled guilty to are two of the charges that fall under that section. So we feel that in changing that 628, adding subsection B and being very specific about this narrow group of individuals that it was tolling the statute for. I'm going to also talk to you about the word accrual.
Let me follow up with you.
Yes, sir.
Though, so you do agree that would be a public policy decision that the legislature ought to make, and not just us, correct? That I won't say abrogating, but making an exception to the claims statute. I guess what I'm hearing you say is that you agree it's a public policy decision that the legislature ought to make, but they made it by making that change to 6-2-8. Is that?
Yes, Justice McCool, that is our position. We believe that when they initiated the changes in 628B in 2019, they did not say, hey, we're going to make these changes. We're going to protect these children, except if it's a municipality, because like Your Honor, you have many, many children that don't disclose. And quite frankly, some time was brought about the mother of our children, being able to bring this today. It wasn't something she knew to do, and children should not be punished from the ignorancy and the lack of knowledge of the adults that they have set to protect them. We have many children that are also in the Department of Human Resources custody. They may be abused. They don't disclose. And once again, who are we to who at that point, the state's in loco parentis. The state would be responsible for filing a claim. It's just such a sticky situation. And I can't recall who asked this question earlier, but I believe it was you, Justice Cook, of how do you propose we harmonize this? We would say, we understand the city has a right to be put on notice. That has been fundamentally unchanged since 1907. We're just asking that in the situation of a children, their accrual is told. So we understand that an issue accrues for them once they turn 19.
So, all right. So that brings up a question that opposing counsel discussed. So if this court were to go along with this, if we were to overrule pardon, if we were to harmonize these statutes, does that mean that your minor client that her claim is it's not ripe?
I believe that there's two situations to answer your question, Justice Wise. 628 is for children to be protected when they don't have an adult to act for them. Thankfully, in this situation, she acted, albeit she did not file that claim within 6 months because she didn't know. We're here. We've got this. We have now since put them on notice. They say that it was not timely. However, we're also dealing with situations where children don't have an adult that do that for them. So our way of harmonizing it would be when they're 19, they have 6 months to file that notice of claim with the city or it's waived. If they have someone to do it for them within the 6 months or someone's at the age of 19 when it happens, then that 6 months would start at that time.
All right.
Thank you.
Counselor.
May it please the court. Justice Wise, I would like to expand upon that question you asked. There are two different scenarios, multiple scenarios, but let's talk about two. If a parent, Justice McCool, is vested with knowledge that their child has been sexually molested, then the parent can file a notice of claim under Title 15 within 6 months. If the parent chooses to pursue a criminal statute, we're going to prosecute the bad guy. Let's try to put the bad guy in jail for doing this. 628B specifically tolls the statute for the child if the parent decides, look, I don't want to prosecute a civil case right now. The child still has that right under 628B. So two things can happen. The person standing in the shoes of the parent, if it's a parent or if it's a adopted parent or if it's someone that the A.G.R has put the child in the custody of, they can file a notice of claim. If they choose not to do that, that doesn't take away the rights of the child. The legislature specifically, intentionally, with knowledge of the laws of the state of Alabama, extended the statute of limitations for children in such a case as this. Pardon case, the law was different. The law was different when pardon was decided by the Alabama Supreme Court. So the defendants in this case, politically, I know it's not popular for courts to change the law. But when the law changes, the courts can then adopt to the modifications to the statutes. And that's what we're asking the court to do here, is to take the new accrual tolling period for children and apply it to the laws of the state of Alabama now. The public policy argument was made against the City of Irondale standing squarely on 628B. That's how that happened. We used 628B to make the public policy argument. Then when the City of Birmingham filed their motion, we put it in there and it was argued in front of the Circuit Court of Jefferson County. And Judge Huey wisely said, this is going to wind up in Montgomery because we have a conflict with these statutes. These statutes have not been harmonized. There's not been a reckoning recognizing the new tolling statute. So, yeah, pardon's 50 years old, but the law was different then. We've got a new law, and we think it's time for the Supreme Court to do something about it, and here we are.
Mr. Wills, I would like to correct you on something very, just for future references. There's no such thing as adopted parents. My daughter was adopted and I'm a parent. I am not an adopted parent.
I have a question about something else in this case. So how do you respond to the claim that these, even if we changed the law, the claim was filed past the 6 months after at least one of the victims became an adult?
Justice McCool, I believe the lawsuit was filed before that child turned 19.
Okay.
So I believe that's just a procedural argument that the defendants are making under Title 15, but I believe the lawsuit was filed. She has subsequently, the oldest child has subsequently reached the age of majority.
Well, the lawsuit was filed, but the city of Birmingham and the city of Irondale weren't named. It's like a friend group of the libraries it was named. So the cities weren't actually named, and the notice didn't go to the cities until after A.J.R had 6 months. It had already passed 6 months past being 19, as I read the record.
Justice Cook, I believe that's correct.
So you would agree that once they reach the age of majority, they've got to file a notice of claim within 6 months?
We don't agree with that, Justice Cook. We believe that this, by the extension of 628B, they have 6 years to file a lawsuit. They have 6 years to bring their legal claim. We believe that the cities are using this general procedural notice statute to trample on the rights of children that are sexually abused when they're under the age of 19.
You don't think the notice of claim statute has any application at all in the sexual abuse?
No, no,
realm?
sir. No, sir. Thank you.
Thank you very much. We will take this case under advisement and we stand adjourned.
All rise. Court is adjourned.